All right,
All
Jeff,
right.
let's get to the mifepristone case.
Yeah, I call it the abortion bill case because I can't pronounce that word. We don't do politics on this show, but super interesting decision that came out by the Supreme Court on June 13th. Interesting for a number of reasons. First of all, it's unanimous, 9-0. Second of all, it has to do with a very controversial topic, abortion. And most women in America, when they get an abortion, get it through this pill. I mean, very controversial. And it not only is it unanimous, but it was completely disposed of on procedural grounds, saying that the doctors in this case who brought the challenge to the approval of this pill don't have standing because none of them prescribed the pill. None of them made a credible case of showing that they have to treat people who take this pill because there's laws that allow a doctor to abstain from treating someone if they have religious or other beliefs about the pill. So the thing that I found super interesting, in addition to being 9-0 and nothing on the merits, no snarky footnotes, no snarky concurrences or dissents, is that there's no reference to the Comstock Act. And the Comstock Act is something that was brought up a lot during oral argument. It's this older law that basically says, hey, you can't send obscene materials through the US mail. And there's some arguments out there that perhaps this old law could be used to ban nationwide the mailing of the abortion pill. And so when this was brought up during oral argument, everybody thought if it wasn't at least going to be decided on this basis, at least some of the folks on the conservative side would drop a footnote forecasting or hinting that they would be receptive to such an argument, or on the liberal side, suggesting why that argument wouldn't fly. It was nothing, totally silent, which suggests to me, perhaps after the Dobbs decision, perhaps the Supreme Court is feeling a little shell shocked and doesn't want to take the heat of another abortion decision. They just really 9-0 issued a lengthy decision about standing.
Yeah,
Uh, that's the only reason I want to bring that case up.
yeah. No, I think that's partly true. That well, I thought the purpose of the majority's purpose in Dobbs was to get the Supreme Court out of the abortion business, and so yeah, I'm not surprised that the conservative justices didn't want to take up the Comstock Act, although
Yeah,
it may have done so to say I don't know why they couldn't get a majority to agree that yeah that argument doesn't fly. But if
yeah,
someone didn't want to go along with it, maybe that's the price of getting a unanimous opinion.
yeah, yeah. One other interesting thing of note: typically Supreme Court decisions don't include a roadmap or instruction manual to, hey guys, you lost this case, but if you want to do it again, here's how you would successfully do this case. There was a paragraph where the Supreme Court basically described, here's what a declaration needs to say from the doctors to have standing in this case: that I'm a doctor, I treated this patient, it was related to the use of this abortion medication, it violated my religious beliefs, and here's why federal law doesn't protect me from stepping back because of my religious beliefs. Really laid it out. And it was unusual for me to read an instruction manual within a Supreme Court opinion.
Yeah, yeah,
Um,
and I was left surprised after reading. I just read the syllabus in this one, but I was left surprised that the Fifth Circuit had found that there was standing because to the extent that I could understand any of the creative arguments for standing, they didn't seem strong to me.